Welcome to P3Q from P3. My name's Darren Woolley, and today we're putting 3 questions to Trevor Choi, the principal of Choi Lawyers, a law firm that specialises in intellectual property and copyright for the advertising and marketing industry. Welcome, Trevor.
Thank you.
So, Trevor, let's start with the basics. What is intellectual property in relation to the advertising and marketing category?
Well, intellectual property is really misunderstood a lot of the time because people think that it covers all work or all ideas produced by marketing creatives, which is not the case. People imagine that it's like a huge umbrella that covers a very, very large area and it covers the whole marketing industry. So any marketing ideas or concepts or product that comes out from that area is going to be covered by this umbrella. Now, that's not actually the case. The reality is IP is like a series of small umbrellas, right? That if your idea or your work, the way it's expressed, is covered by one of these small umbrellas, then it's protected under intellectual property law. If not, it's just out in the open and unprotected. So these umbrellas would be the ways that some concepts would be expressed visually. So you would have photography, you would have illustration, you would also, for example, have music, or you might have performances, you might have various things, but each of these umbrellas is a separate and discrete umbrella. And that's really, together, that's intellectual property, and it means that the output of agencies is going to be covered only to a certain extent. Some things will be covered and some things will not be covered. Generally, an idea has to be expressed. It can't just be an idea by itself. It won't be protected as a pure idea. It'll only be protected in an executed or expressed form, and that form will be what's actually protected.
Trevor, we find with our clients that most of their contracts have the agencies assigning all their IP to the client. What's wrong with this practice?
Well, typically clients do try to grab everything, and that's even things that they don't actually need to own. So, for example, if you were going to stay in London for 6 months, would you buy a house? Well, you probably wouldn't. You'd rent, because you don't need to actually own a place. And you know that if you were to buy a house, the cost to you would be pretty substantial and fairly so. Now, we understand that in the context of houses because we all live or rent a house, or live in or rent a house. But in the area of IP, we're not so familiar with it. And grabbing a house or grabbing ownership of everything can either A, be costly, or B, can sometimes be impossible to do. You just can't comply with some things. If you're licensing photography or music or footage from somewhere else, you can't buy it anyway. You can't buy it outright unless you pay ridiculous amounts of money. So that's the problem with trying to own everything in this area. Physically, it's impossible to comply with in many cases.
But Trevor, isn't there a risk the client could be held to ransom if they don't own all the IP? Or what's the best practice to get around that?
Well, ransom happens for 2 reasons. One is the contract itself wasn't properly negotiated and all the options weren't worked out from the beginning. And 2, usually it's because, not always, but usually it's because one of the people involved, one of the creatives involved, who has intellectual property rights stemming back, feels that they weren't properly compensated for the work that they were doing. They didn't get fair value. So addressing those 2 issues, the first thing is a general statement of if you are making an effort to be fair to everybody, then the likelihood of that is reduced. That doesn't get rid of the greedy factor that does come into it, and some people will be greedy. But then you go to the second bit. And the second bit, I think, is the even more important bit. If you have negotiated everything with the agency so that the agency is aware of all the options, all the different things that can happen, if the work stays with the agency, what happens with rollovers, what happens if it goes into different territories, if all these options are worked out, as per your standard agreement, then you've got these variables locked in. So if anything does happen, you know that you're not paying the full amount up front, but what you're able to do is you're able to say, well, we're going down the path of option A, therefore we'll pay for option A. Should we need to take this overseas, we've already pre-negotiated a fee that the agency is happy with for taking it overseas. So you pay that fee, you've covered that off. If you need to extend it for a longer period of time, then you pay that fee accordingly. And if all these fees are worked out at the right time, which is at the very beginning, when the agencies want to have the work, you'll be able to have decent fees worked out, which both parties should be happy with.
Thanks, Trevor. Thanks for your time. This is the second in our series of vodcasts where we put 3 questions to industry experts and get their responses. For more information, why not check out our website at www.p3.com.au or check out our blog at p3.com.au/blog. Thanks for your time.